Hello everyone. I was tempted to do one of my infamous long threads about the illegal migration bill and what my thoughts were on it, but I've decided to do a video instead because it's going to be quicker, and frankly I'm so angry I'm not even sure I can type straight at the moment. But in any event, there's three particular points that have struck me about this bill. To give a bit of a preamble, very often the European Convention on Human Rights, the ECHR, is presented to us by the tabloids and by MPs themselves as being Europe imposing European law on the British, when in fact the reverse is true. After the Second World War and after the horrors of the Holocaust and Nazi Germany, it was Winston Churchill in particular who was a huge supporter of the European Convention on Human Rights, and the main draftsman for the convention was a chap called David Maxwell Fyfe, who had been a minister under Churchill's government. So the reverse is true. It was actually very much the British imposing British law onto the Europeans. But over the years, so much has been stirred up in terms of claims that the ECHR is only ever used to protect criminals and immigrants, and in fact it actually protects every aspect of our lives, and every right that we have just about can be protected via the ECHR. So when I read first of all the explanatory statement that goes with the bill, so every bill has to have an explanatory statement at the front. The actual explanatory notes of each section of the bill are published as a separate bill. But one of the things that a minister has to do is make a statement under 19(1)(b) of the Human Rights Act 1998 to say, generally speaking, yes, this legislation that I'm proposing is compatible with the European Convention on Human Rights. This time, Suella Braverman, as Secretary of State for the Home Department, has said, I am unable to make a statement that in my view the provisions of the Illegal Migration Bill are compatible with the Convention rights, but the government nevertheless wishes the House to proceed with the bill. So from the get-go she's saying, I know this is illegal in international law, I don't care, I want this bill passed. That to me is a huge alarm bell. But you will have perhaps already heard that the UNHCR has effectively said, well, this stops all asylum claims in the UK. And to an extent, if one buys into the rhetoric of, oh, this is to stop the small boats, and isn't it terrible that these people are trafficked over in small boats and blah, 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 then perhaps you think, well, no, we need to stop the small boats. I happen to agree that we need to stop the small boats, but I believe that we need to stop the small boats by opening legal channels for people to be able to claim asylum in the UK when they need refugee protection. But that's by the by. What is clear from Section 2 of this bill is that it's not just going to stop people in small boats claiming asylum. There is a provision under Section 2 that anyone who arrives with entry clearance that they've obtained through deception is also inadmissible to claim asylum. So what that means, imagine that you want to leave your country, you manage to get a visitor's visa, or you manage to get a student visa, and you manage to flee. The Home Office can say, well, hang on a minute, you're claiming asylum here at port, but your visa was for a visitor. So when you made your declaration saying, yes, I'm only going to visit the UK, that was a lie, wasn't it? You were deceiving the UK authorities. Boom, asylum claim inadmissible. When you said, yes, I'm only coming as a student and I plan to leave at the end of my studies, that was also a lie, wasn't it? So boom, inadmissible for claiming asylum. So effectively, what this would mean is that only people who are given entry clearance for the purpose of seeking asylum will actually be allowed to seek asylum when they arrive. What that means is, for example, if we look at the Ukrainian refugees, the British government facilitated entry for Ukrainian refugees. They also have facilitated entry for a certain number of refugees from Hong Kong, a certain number from Syria who were in refugee camps in the larger Middle East were brought to the UK and given refugee status. A safe corridor was supposed to have been set up for Afghans, particularly those who had worked closely with the UK or US occupying forces in Afghanistan. In fact, last year, only 21 people were settled under that route. But what this effectively means is that the government gets to pick and choose which countries they're going to accept refugees from, and open up corridors to those countries should they feel like it, and set quotas if they feel like it of the number of people they're going to take from the countries they choose. Or they could decide one year that they're actually not going to choose any countries at all. This is entirely contrary to the provisions of the 1951 Refugee Convention. The other point that really struck me as being dangerous is in respect of the powers of detention. So a person may be detained under the authority of an immigration officer if the immigration officer suspects that they fall into the category of people who should be removed from the UK. And bearing in mind it is a duty to remove, the Home Secretary must facilitate the removal of people who are ineligible to apply for asylum. And one of the dangerous parts of this, in particular, is in respect of legal measures. The period that one can be detained for is up to 28 days. You can't get bail until after that 28-day period has elapsed. But secondly, in respect of legal proceedings, it says that in relation to detention during the relevant period, the decision is final and is not liable to be questioned or set aside in any court. In particular, the powers of immigration officer or the Secretary of State, as the case may be, are not to be regarded as having been exceeded by reason of any error made in reaching the decision. The supervisory jurisdiction does not extend to, and no application or petition for judicial review may be made or brought in relation to the decision. So you can be detained for 28 days and effectively have no recourse to the law. That is, in my view, I'm going to use the F word, that is fascist. The purpose of the judiciary is to act as a check and balance against the executive and to prevent the executive from overreaching its powers. When you start saying, well, the executive can make a decision and there is no recourse to law to determine whether that decision is correct or not, is frankly very scary stuff indeed. There is an exception, or there's two exceptions in fact. You can try and seek a judicial review of the Secretary of State's detention of you if you can show that the Secretary of State or her agents have acted in bad faith, or if the decision is procedurally defective in such a way as that it amounts to a fundamental breach of the principles of natural justice. But again, those are very, very high hurdles to overcome. The other exception, of course, is to any person will be able to apply for a writ of habeas corpus. But again, that is a very high hurdle to overcome. Habeas corpus is unlawful detention. It's effectively the executive detaining you without any lawful backing. And where you have legislation that specifically permits you to detain somebody, it's very, very difficult indeed to say, well, actually, no, I'm not being detained properly. So in summary, I'm very concerned indeed at the way this is going. We have already seen some very serious legislation restricting people's human rights. The rights of gypsies, Roma and travellers have been completely trashed. The right to protest is being trashed. The right not to be tortured or killed by an undercover cop, or rather the right to have any remit in law if an undercover cop behaves in a criminal fashion towards you, has also been trashed. There's so many things that have been trashed by this government, and so far they've got away with it. What I am genuinely concerned about is that this derogation, this blatant derogation from the ECHR, is setting a standard. And we had Robert Jenrick on LBC saying that Gary Lineker doesn't represent public opinion. Well, I'm sorry, but public opinion is created, it's manufactured. And if you keep telling the public this is what we need to do to stop small boats, because the people coming on the small boats are all criminals and they're harming your country, of course people that don't understand the background to it all are going to think, well, yeah, we don't want those people here, we need to stop them. But once you start derogating from the European Convention on Human Rights for that, there is nothing to stop them derogating again and again and again. I've heard people saying it's unpleasant, but it is true. The Holocaust was lawful in Germany. That doesn't mean it was right. And it certainly doesn't mean that it's right to keep derogating from the European Convention on Human Rights. So that's my rant for the day. I'm speaking as myself. I'm not speaking on anybody else's behalf. I'm certainly not speaking on behalf of any of my colleagues. But I'm going to be fighting this as much as I possibly can. Thank you.